Mr. Sweeting.
My lords, my lady, thought I would begin by trying to encapsulate what the respondent says is the general answer to the rather elusive question that arises in this case. I start, please, with the 1984 Act. Firstly, we say that the specific aim of the 1984 Act is that the length of time you have to bring a claim, which is governed by foreign law, before the English courts is not the period of time fixed by the Limitation Act. That was the old law, and that is now abolished by Section 1.1. The general aim, on the contrary, of the Act is that you should have as long to bring your action before the English courts as the lex causae, here the law of Iraq, says that you have to bring the proceedings before the English courts. The aim of the 1984 Act is, however, not that you have as long to bring your claim before the English courts as you have to bring your claim before the courts of Iraq, because the claim is not being brought in the courts of Iraq. The questions which arise in this case, we suggest, are as follows. Firstly, which country's law applies to define the time limit on bringing these claims? That's Iraqi law. Secondly, what is the law of Iraq on the time limit for bringing these claims? According to Article 232, 3 years from the date on which the cause of action accrues under the terms of Iraqi law. Next, does Iraqi law make any provision for the stopping of the clock and the consequent extension of time for the bringing of claims beyond the 3 years provided by Article 232? The answer is that it does. Then one would have to go on to consider how and to what extent the law of Iraq provides for the stopping of the clock and the extension of the time period for the bringing of the claims. The answer to that is that Article 435 of the Civil Code provides that if there is a lawful impediment to the bringing of proceedings, that lawful impediment will prevent the clock from running.
Does it have to be a lawful impediment? It's just an impediment, isn't it? Yeah, I mean, if you had a practical impediment, suppose you'd been kidnapped.
Yes, I think by lawful what I mean is an impediment which is within Article 435. It may be that that is tautologous.
Yes.
Doesn't add anything.
An impediment recognised by law.
Precisely, yes. The next question is therefore, how and to what extent is there, as a matter of Iraqi law, an impediment to the bringing of proceedings between these litigating parties? What is the impediment, what does it impede, and how does it impede it? We would suggest that it's necessary to answer those questions in two parts. Firstly, insofar as the proceedings in question are proceedings to be brought before the courts of Iraq, the clock stopped in 2003 or 2004. And whether it will start again is unknown, it's unknowable. But if at some future stage CPA Order 17 was repealed retrospectively, then we would accept that the clock would start running again. However, insofar as these proceedings are proceedings to be brought outside the courts of Iraq, there is no interruption. Certainly no interruption to proceedings before the courts of a country outside Iraq can be attributed to CPA Order 17, because it applies wholly within the confines of Iraq. And that series of questions and answers is the appropriate way to avoid the absurdity which would follow if the 1984 Act were read to mean, as the claimants say it is, that because the claim cannot be brought before the courts of Iraq, it may, without limit of timing, be brought in countries outside of Iraq. That is not what the Iraqi law of limitation says. It's not what the 1984 Act means, and we would suggest that it's impossibly hard to see why that would make sense as a construction of the Act and the Iraqi law which it is seeking to apply. We suggest that the test under English law is not to step into the shoes of a foreign court, determine some hypothetical dispute within that court's jurisdiction. It's to apply the law of that other country relating to limitation in respect of the determination of the matter for the purpose of the action or proceedings, and indeed that's precisely what the 1984 Act says. This action is not, of course, proceeding in Iraq, it's necessarily proceeding in England. The task of the English court, therefore, is to take Iraqi limitation law outside of its territorial scope and apply it to this English action in the way in which an Iraqi court would if it were dealing with the issue before the English court. And we can see that that is the correct approach on good and long-standing authority, not least in the analysis of Lord Justice Scott in the Tolina case. You have that in Volume 1, Tab 7, MS 736.
Yep.
And if you turn to MS 745, it's the left-hand column. At the top of the column, beginning scrutinise. In this passage, Justice Scott is dealing with the role that the expert evidence plays in informing the court about the role of Iraqi law and how foreign law is to be decided. Mm-hmm. And if one reads down a little, we see, in order to convey to the English court the meaning and effect which a court of the foreign country would attribute to it if it applied correctly the law of that country to the questions under investigation by the English court. And that is the linchpin, really, of the exercise, that Iraqi law is being applied to the question which arises in the English proceedings. The purpose of adopting the approach of the local court to local law is, we would suggest, a break on what would be unwarranted judicial invention within this jurisdiction, but what it does not require are parallel proceedings to be hypothesized and to be carried through to decide what the conclusion of those proceedings would be in a foreign court. Indeed, none of the academic commentators goes further than that. All of them say, in effect, that the English court has to decide how the foreign law would be applied by the foreign court, not what the outcome of the case or the issue would be if it were being litigated in a foreign court. Might I just deal with one of the academic commentaries which my learned friend relied on for contrary effect this morning. That is in his supplementary bundle, and it's the Professor Fenterman's article. It's at MS 831 in the supplementary bundle, tab 47.
There's a continuous MS numbering, is there?
No.
You've got 831.
229, I think. Yeah, supplementary.
229.
229.
Yeah.
And
Thank
it's
you.
in paragraph 2020.
Yeah.
You'll recollect this from a learned friend's submissions. The court's role is defined by two principles. First, its task is not normative but predictive. The judge's role is not to determine what foreign law is, but to decide what a foreign court would be likely to conclude if the matter came before it.
Yes.
Now, it may be the semantic difficulty with that is the use of the word conclude, because the exercise is not in our submission anything like considering what the conclusion of the case would be. If it is confined to what the foreign court would conclude, applying its own law to the issue before the English court, then certainly there's no distinction between us in relation to the exercise. And we can see, in fact, that if one looks at the footnote, which refer to the cases which are put forward as supporting that proposition, it's footnote 37.
Yes.
We have three cases there. Perhaps the one to look at is the Blue Sky case.
Look at the contrast being made there, isn't it? It is between
determining what the foreign law is
Yes.
and deciding what a foreign court would be likely to conclude the foreign law was.
Yes, precisely. And, Lord, we certainly say that is entirely consistent with the approach that we urge on your lordships and your lady.
But I don't see how it helps in deciding this case. I understand the point, but how does it help decide?
My Lord, it helps in this sense that the issue which we say arises in the case is, for example, whether it was impossible to bring these proceedings. That has to be decided in the context of the claim which is in fact before the court, not in the context of a piece of litigation which has never been brought, which is being run in parallel, hypothetically.
No, I understand that's your point. All I'm saying is I don't understand how this paragraph helps.
Well, I'm simply saying I think this was being relied on by my learned friend as asserting the contrary, that one did have to look at the approach of the foreign court and decide what the foreign court would do if it was deciding the case.
Are you distinguishing between evidence of the contents of the foreign law, as a court would decide it, and evidence of the facts to which that foreign law might then fall to be applied, where one does not look at what the foreign court would think about what the relevant facts were?
Yes, because the facts arise in these proceedings, and one is not conducting the proceedings in a foreign court. One is simply using a different legal system for the purpose of one of the issues, or more, which arise in the proceedings in front of the English court. Well, I was just going to take you to the Blue Sky case, though it may simply be worth just finishing that off if your lordship...
The difficulty about this is that the Foreign Limitation Periods Act creates a rather unfamiliar position where almost by definition the Foreign Limitation Act or legislation can't be applied in the way it would be applied in the foreign courts because its terms will be confined to proceedings in the foreign jurisdiction.
Yes.
But watch, and I'm not sure that these statements are dealing with this situation. If you look at the legislation, what we've got to do is apply the law of Iraq relating to limitation for the purposes of the English action or proceedings. It says for the purposes of the action or proceedings. That's the English one. So we do have to undertake a transposition exercise.
Precisely. Well, my lord, I think that's always been our case. That
and it may be that literally the Iraqi law won't apply. It won't apply, but we have to see how it applies sensibly in the new home.
Yes.
Yeah.
Well, that is in fact a submission which we've made from the very early stages in the case as to what the exercise is that the court is undertaking. I was really taking the opportunity to deal with my learned friend's contention that it is subtly, if not radically different from that, because you have to in some way consider what the outcome would be if this case were in fact being decided in Iraq. That's what I understand to be the end position.
But, I mean, most foreign law isn't related to the foreign proceedings. It's related to some other concept, like a contract, and so you can apply it without this problem but when you start to incorporate into domestic law procedural matters which are necessarily related to the foreign proceedings, you get the difficulty we have in this case. So it's a special difficulty, which it seems to me at the moment.
Yes, Lord, with respect, your lordship is right. The difficulty is perhaps created by the inclusive nature of the test under Section 4 of the Act in relation to what can be taken into account, the law relating to limitation, and in this case a domestic provision of Iraqi law that uses the term impossibility, which encompasses both factual and legal impossibility. So, Lord, I'm certainly coming directly to the Act and where the Act takes us. Well, can I just, whilst we have that bundle open, just go back to tab 41 and to MS 143.
Yep.
It's paragraph 29. It's
Yes. This is
Lord Mance's observation there that you were taken to this in relation to
the element of interplay and circularity.
Absolutely.
Sorry, can you give me the page reference again?
It's MS 143, or the supplementary, page 143.
How do we pronounce the name of this case?
Well, I think it's Raiffeisen, but I don't know if
It
I'm...
is indeed. I mean, it's
grateful.
Austrian Bank.
I think that's how I pronounce it.
Raiffeisen Zentralbank.
I'm going to call it 5-star.
Although,
Yep. Anyway,
Central Bank, I can do. It's Raiffeisen, I wasn't so sure about.
I think
Paragraph
Raiffeisen
29.
is the way to go. My Lord, I just draw attention to this. I think, my Lord, it really
it's
plays...
appropriate principles rather than application of rigid.
Absolutely. So the three-stage test, in the sense that it's a test, has to be seen in that light.
Yeah.
It was something that your Lordship's new lady were taken to by my learned friend. Well, can I just mention in that context then that the example that my learned friend gave of section 2.3
Yes.
being dispositive
Yes.
is nothing of the kind. You'll recollect that's the provision which
disregard
hinges
the
on
absence in
absence
another
from
country.
Mauritania. That's right. The reason for that is simply that this is an example of a law which, within the meaning of the words in the 1984 Act, makes provision with respect to a limitation period. So it would have to be taken into account, barring the exception by the English court. That's not the position with CPA Order 17. So it isn't a clue as to how one approaches the inclusion of a procedural law of the sort which CPA Order 17 is, in the form of a procedural bar. So, well, may I turn to the 1984 Act itself in the first of the authorities volumes at MS 614.
Yep.
Well, these are, in short, the points which to make in relation to that. Firstly, the reference to action or proceedings that we see in Section 1 of the Act can only be a reference to proceedings in England.
Yep.
I think the point, my Lord.
Well, it says because there are proceedings in a court in England and Wales.
Precisely.
So there must be,
That's
yeah.
right. So it plainly is the starting position. It's rather axiomatic, perhaps, that is the exercise which the court is doing.
Yeah.
The point Lord Nance made a moment ago. Indeed, that's put beyond doubt by Section 3, of course, which preserves the role of the English court in determining when the proceedings commenced.
Yes.
Under Section 1.1, a matter falls to be determined for the purpose of these proceedings in accordance with the lex causae, but not all of the lex causae. It's only that which is applicable by virtue of the 1984 Act, and that which is applicable is the law relating to limitation. And that brings us to the definition in Section 4, MS 619, which is an inclusionary definition. So, my Lord, looking firstly at Section 4.1,
Yep.
the relevant law, that which is relevant for the purpose of the exercise under the Act, is a law which makes provision with respect to a limitation period. And the examples which are given in subsection A are simply examples of a law which makes provision with respect to a limitation period. Thus, a law which makes provision in relation to the application of the period, or the extension of the period, or the reduction or interruption of the period. But all of them turn upon their being identified within Section 4 as a law which makes provision with respect to a limitation period. And, my Lord, that was a vital point as far as the Court of Appeal was concerned. It's probably best expressed in the judgment of Lord Justice Voss, which we can see at MS 150.
Paragraph.
Well, paragraphs 49 to 51.
Thank you.
dealing with how CPA 17 as a rule or law of Iraq fits in to that definition of whether or not it's a relevant law. He observes at 49 that it's more difficult to say that CPA 17 does not relate to the interruption of a limitation period, and then goes on to say that the judge decided in paragraph 40 of his judgment the effect of CPA 17 was to suspend indefinitely the time limit for bringing these claims. But at 50 is the nub of it. He says, I've concluded, however, that neither provision of CPA 17 actually falls within even the extended meaning in section 4.1 of FILPA. That's because, in my judgment, the provisions of section 4.1a are a little more complex than they at first appear. The words references to so much of the law in section 4.1a refer back to the words so much of the relevant law of the country as in any manner makes provision with respect to a limitation period applicable to the bringing of proceedings in respect of that matter in the main body of section 4.1. So they can't be construed in isolation, by which he means 4.1a. In each case, they have to be a reference to a law which makes provision in respect of a limitation period. Well, where does that take us? Well, Article 435 of the Iraqi Code is plainly a law which makes provision with respect to a limitation period. Equally, it's not in doubt that CPA Order 17 does not make provision with respect to a limitation period. It's not part of Iraqi limitation law, it's not part of the Iraqi Civil Code in relation to limitation. And so if the question is framed in terms of whether our Order 17 made it impossible to claim the claimant's right, then that might suggest strongly that relying on CPA Order 17 does involve the court in applying part of the law of the Lex Causae, which is not the relevant law, and so not permissible under the 1984 Act. That is what the Court of Appeal concluded, and we say that was the right conclusion.
Well, the argument against you is that it's not CP 17 which by itself makes it impossible. The provision which extends, which is incorporated, is Article 435, and that refers to another impediment. The impediment itself doesn't have to be a limitation impediment. It could be a fact, like being in prison, or it could be CP 17, a rule which is not a rule of limitation, but is nonetheless said to be the sort of impediment which is included in 435.
Yes, my Lord, I think the way it's put is that either the question is entirely factual, so you stop, as it were, at whether or not it's impossible, and you say that that factual question has already been decided because, yes, CPA Order 17 makes it impossible, or I think the other way it's put is that at most it involves the court having regard to some other provision of law of Iraq.
Yes, I mean,
without actually applying.
I don't know whether impediment includes being a child, for example, but it might be
Referred
some.
to a child earlier on, I think.
Well, there's specific reference to that.
Well, that's a good example that an impediment might be some other legal thing which has nothing to do with limitation.
Well, that's right, but of course that impediment is an impediment which is contained within a law which does relate to limitation. So it would come into the 1984 Act definition in Section 4 because it specifically mentions limitation.
I know, but if impediment,
If it is an impediment.
if it is an impediment, then it comes within 435.
Yes.
So anyway,
Yes, my Lord, because it's specifically mentioned.
But I mean, the ordinary language of another impediment in that context is anything which renders it impossible. And on the first argument, whether it's a statute or a state of fact, seems that it's a bit strange that if it's a statute which is not referred to in the earlier part, then it's not an impediment. Well, why shouldn't it be an impediment?
Well, my Lord, the answer is...
A matter of ordinary language.
Well, I suppose as a matter of ordinary language, impediments may be either factual
Yeah.
or they may be legal
Absolutely.
impediments. And that's undoubtedly right. And as far as the factual impediments are concerned, the claimants have set out a case as to why, absent CPA Order 17, there would have been factual impediments to the bringing of a claim in Iraq. Whether or not that's the right approach, it suffices to say that that is the position. But what in fact is being relied on is legal impossibility as an impediment, because that's what CPA Order 17 provides. It's a legally impossible
But it seems to be common ground that, am I wrong, that the words another impediment could, in Iraqi law, be regarded as including CP 17? In other words, CP 17 is an excuse for not suing unless and until the state chooses to waive its immunity, after which you then have 3 years, even if that takes place in 100 years' time.
in Iraq, certainly. That's the first.
So, I mean, why not? I think we raised this right at the beginning. It's perhaps slightly surprising to think that in 435 they were even thinking of a bar like state immunity or CP 17, but it seems to have been accepted they might have been in Iraq.
Well, Lord, I think
were in Iraq.
what's accepted is that if an action was being brought in Iraq, then it would plainly not be possible to bring it because of the immunity. And indeed, I think the point we made for the Court of Appeal, which was described as beguiling and attractive, if not right, was that the Iraqi court, if one was considering it hypothetically, wouldn't even get on to the question of the application of the limitation law.
And it could only ever be relevant if at some point outside the 3-year period the state chose to waive its immunity, which is pretty, which is theoretically possible.
Theoretically possible, I think.
And then apparently there wouldn't be any other limitation period unless this one applied.
Well, that's right.
Yeah.
But as far as legal impossibility is concerned, obviously within Iraq, which is the general point I made to begin with, the position is different because of Order 17 to the position in English proceedings, where CPA Order 17 simply doesn't run. It can't be regarded as impossible in relation to proceedings which are being brought in this country. I obviously made that point. But, my Lord, because it's legal impossibility, the question really is whether the test which is set out in Section 4, in other words, whether it's a provision which is part of the relevant law, makes provision for a limitation period, is something which the court has to apply, where what's being relied on is a provision of Iraqi law. And that is conceptually different from simply saying, well, we're relying on factual impossibility. We're not dealing with factual impossibility, we're dealing with legal impossibility. And our submission is the Court of Appeal was right to say that if what is being relied upon as impossibility under 435 is in fact another provision of Iraqi law, then the court is in effect giving effect to that other provision, and it can only do so if it passes the test set out in Section 4. In other words, it's a part of the law which is making provision in respect to a limitation period. Order 17, of course, is a form of status-based immunity. It gives immunity to someone who is a member of the multinational forces in relation to actions which might otherwise be brought in Iraq. And well, I suppose one could test it by saying, suppose the impediment wasn't a status-based immunity, it was some form of disqualification. Say the disqualification was one from taking proceedings, which was based on gender, race, religion, or sexual orientation, all things which might offend public policy, would therefore be subject to the exception in Section 2. I mean, the argument could hardly be in those circumstances, well, the court doesn't have to get any further beyond the analysis, which is, well, as a result of one of those disqualifications, it's simply factually impossible. It would have to, for the purpose of applying the exception, have to consider what law was being given effect to. And indeed, unless the law was being given effect to, it's difficult to see how it would be contrary to English public policy, where plainly one would consider that those sorts of disqualifications, if they were being used as a way of indefinitely postponing the inception of a limitation period or interrupting it, would in fact be subject to a public policy argument. And if that's right, then it cannot be the position that one simply says, well, even though this is a legal impediment which is being relied on, the court simply looks no further than saying, well, that is effectively synonymous with a factual impossibility. The court is bound to look at what the nature of the legal impediment is, which is effectively what the Court of Appeal was saying. And indeed, it's the basis of the ratio in the UKSC case. And one might, in fact, I suppose, consider another example which might be closer if the position were that one could only bring proceedings with the permission of a tribal elder or a religious leader, and that permission wasn't forthcoming and couldn't be challenged. Would it be said that that simply involved no more exploration by the court than saying, well, that's just an example of impossibility, even though the impossibility is a legal one, and it's the sort of impossibility which is plainly simply a procedural bar. It's the form of bar which arises here as a result of immunity, not a disqualification. But the idea that one wouldn't... My Lord, you were going to ask a question.
Well, I just wondered whether that might be said to be a question of what the Iraqi court would say, whether that was regarded as an impossibility. That would be just the sort of thing one might say would be a matter of Iraqi law.
Well, Lord, I'm positing that the position is that in order to bring a claim,
Correct.
you, for example, need the permission
You say that
of somebody else.
You say that would be ignored or taken into account?
Well, my Lord, if that, in fact, prevented you from bringing a claim, on the face of it, that would be a form of procedural bar. If Iraqi law says, as a matter of procedure, without the permission of your husband or your tribal elder or your religious leader, you can't bring a claim.
I mean, the first step would be, wouldn't it, to find out whether that was a sort of impossibility that brought it within the closing words of 4351. But if it was, according to an Iraqi court, would that apply in this court, according to you?
No.
It wouldn't.
No. And the reason is for precisely the reasoning set out in the Court of Appeal, that in those circumstances,
Quite, that's what I thought.
what you would be dealing with is a procedural bar, and you would be giving effect to a part of Iraqi law which doesn't fall within the definition of Section 4.
Yes, sir.
Because that is not something which makes provision in relation to a limitation period. It's just a straightforward procedural bar. And in fact, in the judgments in the Court of Appeal, that argument was run and dealt with.
Yeah.
It's paragraph 31. The judgment of Lord Justice Tomlinson, it's MS 146.
Thank you.
At the top of that page, which is in fact about halfway into paragraph 31, Lord Justice Tomlinson says, so here the claimants are inviting the court to give effect to CPA 17, which is a procedural bar to an action in Iraq, as the foundation for a finding that in Iraqi law the actions would be regarded as not time-barred. And
But I haven't, which paragraph? I haven't got it again.
Right,
Where was it?
right,
it's-
second line.
Second line,
Second
page
line.
146.
Oh, yes, thank you. Yes, I'm with you.
And then he goes on to say, if we're to regard Ugruneft as correctly decided, as in my view we should apply the same approach here as was applied in that case. True it is that in Ugruneft there was no equivalent of Article 435, which is part of the Iraqi law of limitation, which if it's engaged must apply, but that seems to me as a distinction without a difference.
I mean, is that characterization of what the claimants are submitting right? The claimants, as it seems to me, are not inviting the court to give effect to CPA 17. They are simply inviting the court to recognise as a matter of fact that CPA 17 prevents proceedings in Iraq, thereby pushing you to the real issue, namely whether the question is what is impossible in Iraq or what is impossible in England.
Well, Lord, I think there are two strands. The first part of my submissions, where I tried to summarise what our position is what was characterised, I think, as issue 3 before the lunch adjournment, which is part of our addendum argument, which is that is precisely what the court should be doing, looking at impossibility in relation to these proceedings in England. That's right.
But if the appellants are right to say that the relevant question is what's impossible in Iraq, it doesn't involve giving effect to CPA 17, simply to find as a fact that it prevents proceedings in Iraq.
Well, I suppose that then depends upon what one means by giving effect to.
Yeah, I mean, there's a difference between giving effect to something and simply treating it as the basis of a factual finding.
Yes, but
you can't do it in Iraq.
But the factual finding here is in fact a finding that there was a legal impediment, that it was legally impossible to bring the proceedings. So for the reasons I suggested in relation to the example I gave, what one is in fact doing is allowing a procedural bar to operate in these proceedings when there is in fact no procedural bar which prevents these proceedings being brought.
Well, that's the third point, not the first.
Well, Lord, I think it's the logical sequitur, as it were, of where one goes if one...
Maybe that dividing them up into separate points creates more problems than it's worth.
Well,
but there are clearly distinct ways of looking at this, and it all ultimately boils down to the question, impossibility where?
Yes, well, Lord, I think, as you know, our primary submission, although we've raised it by way of an addendum, but it's one that we've raised from the start, is that impossibility to make the Act work coherently must be impossibility in these proceedings, not impossibility in Iraq, really, for the reasons I set out. And CPA Order 17 is a good example. It makes very little sense to be looking at impossibility in Iraq when the proceedings have never been in Iraq. They've always been run in this country, in this jurisdiction. But, my Lord, in any event, we do say, nevertheless, that the Court of Appeal was right to conclude that if, as part of the analysis which is being conducted under the 1984 Act, the court is going to accept that the proceedings were not possible, they were impossible as a result of a legal provision of Iraqi law, then one has to apply the definition in Section 4. And I suppose the issue is whether one stops at applying that to 435, which we accept is a provision which is a rule which makes provision in relation to a limitation period, or whether one goes on. Now, Lord, I don't need to repeat my submissions. We would say that can't be right, because the court is always going to have to look at and characterise any legal provision which is relied upon as interrupting the limitation period. It would have to do it for the purpose of determining whether it was contrary to public policy. The point I made a moment ago, you don't just stop, as it were, at the you don't stop at the doorstep and don't ask whether you're not going out because it's raining or it's dark. You don't just say it's a factual question at that point. If the legal impossibility, if the impediment is a legal one, one has to characterise whether or not it is an admissible one under Section 4.
Yes, well, I mean, I'm troubled by that. Supposing that the Iraqi law had said no Iraqi civilian shall, on pain of imprisonment for a minimum of 10 years, bring any proceedings against the coalition forces anywhere in the world, then would the English court really say, oh, well, that's irrelevant as far as we're concerned, that's not an impediment? Answer, I would have thought quite likely no. So the strength of your case, if that's right, is based entirely on the fact that, not on the nature of CP17, but on the fact that it's only intended to affect Iraqi proceedings. It's intended to allow precisely the present sort of proceedings to go ahead in the home state, in which case there's no reason why they couldn't have gone ahead within the relevant limitation period. That's the third point, probably.
My Lord, yes, yeah. within these proceedings, in this jurisdiction, that's undoubtedly right. Lord, I'm not sure if the example which your Lordship gave, though, is one that wouldn't be caught by...
By your submissions?
Well, yes, by the
Well, it'd be pretty tough if you were time barred when if that wasn't a relevant impediment in English proceedings as well as in Iraqi, but still, maybe that's your submission.
Well, my Lord, well, I think if your Lordship wouldn't mind just repeating what...
Well, the relevant impediment I was proposing was that these claimants, who are all, I understand, likely to be resident in Iraq at all material times, were subject to a prohibition enforceable by criminal penalty against bringing suit against the coalition forces anywhere in the world. I mean, maybe one could have qualifications, without permission or something, but anyway, let's assume it was in legal and practical terms impossible for that reason for them to bring proceedings until now, 10 years after the event, when suddenly the prohibition is lifted. Are we really to say that they would be out of time in English proceedings?
Well, Lord, if the provision is a provision which deals with a limitation period, in other words, it makes provision in relation to a limitation period,
well, I got it, yes.
Which I think is the example your Lordship is giving me, then in fact it would pass the section 4
No, it's not.
test.
I'm simply got an extended CP17, which you say, and I think is common ground, is not a limitation provision.
Yes.
So I've got there's immunity in respect of all proceedings anywhere, right? And this is enforceable by criminal sanction. That's not a limitation provision. Your submission is we have to ignore it and say you should have sued within 3 years.
Well, subject, I suppose, only to
undue hardship.
Public policy.
Yes, precisely. So you say
exception.
That you both rely on the let out.
Well, we do, but I think the point I would make is that in the approach we are advocating, the court would be looking at and characterising the legal provision of Iraqi law. We wouldn't simply be saying, well, actually it's just factually impossible for reasons which don't matter. We would be saying it was impossible for reasons which can be examined in the context of whether or not that would be contrary to English public policy, for example. Undue hardship is, of course, just one example of the general public policy exception. So the point I was making earlier is that if it's irrelevant to go beyond saying, well, is it factually impossible because of a legal impediment, and without looking at the nature of the legal impediment, it's difficult to see how you'd operate the public policy exception, because it's only if you would be giving effect to something which was contrary to public policy that Section 2 would bite.
Yes, I see.
So the reason I say that's a good example of why the exercise is not just stop because it's factually impossible, albeit by legal impediment. It does involve looking at the characterization of the underlying rule of Iraqi law, which you are giving effect to. So, well, that's...
It's paradoxical. Is it fair to say that both sides are advocating the possibility that this legislation may lead to odd results mitigated by the let-out provision?
Well, Milord, can I say firstly that on our primary submission, which is effectively what was Rule 3 this morning, or Example 3, Issue 3,
Public policy provision is intended, presumably, to be a very narrow one in the usual way. You're not intended to arrive easily at a public policy let out.
No, and it would, as a matter of fact, be particularly difficult to apply it other than on a case-by-case basis in relation to claims of these sort.
We ought presumably to construe the Act in a way that appears to make some kind of sense, having regard to its purpose, notwithstanding that if we arrive at a balmy result, we might have a let out under some other provision.
My Lord, absolutely, and that's why, I say in answer to your Lordship's question, that in fact the coherent way of approaching it is our primary submission, which is to say that if you are bringing proceedings in this country and the law which you have to apply asks the court to determine whether or not it was impossible to bring those proceedings, that one should answer those questions by reference to impossibility within this jurisdiction. That's the first point. Now, it becomes a slightly more nuanced argument in relation to that because, of course, it may well be that factual impossibility arises in relation to whether or not someone who was in Iraq, who was living in a village somewhere, could factually have conceived of and brought proceedings or instructed someone to bring proceedings in this country. So it's not simply a case of saying, well, it was always open to you to bring proceedings. There are layers of factual impossibility which would no doubt arise. But the coherent way of approaching it is to say that we are looking at a single jurisdiction, and that is where the claims are being brought. The difficulty otherwise is that one is in a situation where we are looking at whether or not it was impossible, factually, to bring proceedings in Iraq when those proceedings have never been brought in Iraq, and there would be an interruption of the applicable limitation period in this country, presumably on an on and off basis, according to whether or not the courts were open, there were other impediments to access to justice, and so on. And that, well, it was a vernacular term, but that does seem balmy, as your Lordship perhaps posits, to have a situation in which we are considering interruptions to the limitation period here by reference to things which were going on in Iraq. And by the same token, if one approaches the application of CP Older 17, in other words, it doesn't apply to proceedings brought here for the reasons I set out at the start, that produces a consistent result. Neither CPA Order 17, the immunity in relation to proceedings in Iraq, nor events on the ground, as it were, in Iraq, would provide the basis for an argument there was factual impossibility. Subject only to someone saying, in fact, there were real impediments to me instructing someone to bring my proceedings in Iraq. It's also the answer, if I may say so, to the prison example, which was posited, I think, before lunchtime. If the prison example, someone was in prison and there was a provision of Iraqi law which said that that interrupted the limitation period, that would be a qualifying provision under Section 4 of the 1984 Act. It would fall to be taken into account if it made provision in respect to the limitation period. If it was simply, I was in prison in Iraq, I simply didn't have the wherewithal to instruct someone in this country to take proceedings for me, that would be factual impossibility which would sound in these proceedings in this country. There is no difficulty in accommodating that in a rational approach to whether or not it was impossible to bring these proceedings rather than some hypothesized proceedings in Iraq. So, Lord, it may be it all comes back to that, and our starting position is that the third question, which was being addressed before lunch, is actually the right result. One considers impossibility in the English context throughout. But in any event, even if that's not correct, the Court of Appeal was right to say that one still has to, when you're looking at impossibility as a result of a legal impediment, to consider the scheme of the 1984 Act, and in particular the qualification set out in Section 4 as to what can be taken into account. And that also produces a rational result, because it does mean that if you have the procedural bar of the sort that existed in the Ubranef case, if you have a procedural bar of the sort which I posited where one has to get permission from a spouse or a tribal leader in order to start proceedings, and that in fact made it impossible, those are bars which would not pass the inclusionary test in Section 4 of the 1984 Act, and they would not fall to be taken into account. And there's no reason why they should, because there is no sense in which they precluded the bringing of an action in this country. So, my Lord, as an approach to CPA Order 17, which is what the Court of Appeal was concentrating on below, the question of whether that was part of the relevant law of Iraq was precisely the right question, and it produces a rational result. The position would be even more coherent, if I can put it in that way, if the question of impossibility was always answered by reference to whether it was impossible to bring the proceedings where they have in fact been brought. And that was the effect of applying Article 435. My Lord, I think my learned friend was asked about authority for the propositions which are being argued on either side this morning. I think the only one in which we relied on in the Court of Appeal was, of course, the Ugruneft case. And we do say that that comes closest to an articulation of the case we're advancing here, which is simply that if one is going to apply or disapply Russian procedural law, then it ought to be disapplied in full. That is precisely analogous with the position we're in this case, and that the result in Ugruneft, as well as the reasoning, supports the argument that we're advancing, which the Court of Appeal accepted in relation to CPA Order 17. Well, it's perhaps worth looking at the relevant part of Ugruneft. It's in Authorities Volume 2.
Which tab?
It's
21.
Yes, chapter 21. And MS 127.
MS
1247, sorry.
That sounds more like it.
Yes.
It's not paragraph. Yep.
So paragraph 311 Mr. Justice Clark, as he was then. So if the sole matter at issue was whether or not the Russian courts applying Russian law and procedure would or could dismiss a claim based on criminal conduct on the ground of limitation in the absence of a criminal finding, at any rate at the end of the criminal liability period, I would not have thought it appropriate, despite my doubts about Professor Sergeyev's logic, to attempt to resolve the question on a summary application. But the question for decision, in my judgment, is somewhat different. Ugrunef's claims would be unmaintainable in Russia for want of a criminal finding. However, for private international law purposes, it is necessary to ignore the Russian practice not to entertain civil claims based on criminal conduct in the absence of a finding as being a procedural matter. Ugruneft invokes that principle, but if the court is to ignore the practice, then as it seems to me it should ignore the whole of it. Professor Sergeyev's report makes clear that the practice of deeming the victim's knowledge to crystallize upon the event of a criminal finding is part and parcel of its practice not to entertain a claim based on criminal conduct in the absence of a criminal finding. The point being that that was not a rule or practice of Russian law that made provision with respect to a limitation period. If the appellant is right about its approach, it plainly would have been simply regarded as a factual impediment, which would be taken into account by the English court. But as here, it was in effect a procedural bar. The action could go no further. It was forever stymied by the fact that there had not been a criminal investigation. That was what was being relied upon. In reality, of course, that is precisely analogous to the present position where any action is indefinitely postponed until some theoretical waiver, which now that the UK has left Iraq is unlikely to arise at all. And we are in the same position as in the Ugruneft case, where the court is being effectively invited to give effect to a procedural bar, which was the position in Ugruneft, in order to have an effect upon the limitation period. And for the same reason as in Ugruneft, the court declined to do that. The Court of Appeal was right to say that was exactly the same approach which should be adopted in relation to CPA Order 17. In other words, a procedural bar which is not part of the law of limitation. And of course, as soon as that is the position, we are squarely back into the distinction between applying procedural or substantive law, and the procedural law is a matter for the forum and is not to be applied in relation to the determination of the claim. Lord, I think, apart from that, I think there is no other authority, but that is an authority which is supportive of the approach and was certainly regarded by the Court of Appeal as being one which offered assistance in relation to whether or not it was necessary to categorise CPO Order 17 as a procedural bar and therefore not within Section 4. Well, those are my submissions on the two principal points. One is that impossibility ought to be decided by reference to the English proceedings for the reasons I set out earlier. Secondly, that the approach taken by the Court of Appeal to CPA Order 17 was the correct one. Lord, I think in relation to what remains, which was issue 2, which I think was skipped over this morning, I'd be content to leave that as a matter of our written submissions in the addendum. That's the private international law point and renvoi, unless your lordships want me to develop that.
Thank you very much.
Thank you.
Yeah, of course. Now,
My lords, my lady, my learned friend's submissions are expressly based on what the law ought to be, not what it is. And that's a critique we say can be fairly levelled both as to his approach to Iraqi law and English statute. And I want to make that good, if I may, in reply, by just setting out the relevant phases of the treatment by the English courts of foreign law. And I'm going to suggest there are 3 relevant phases. Firstly, characterization of an issue. Secondly, once you've characterized and identified the relevant law, interpretation of the relevant law. And finally, application of the relevant law. So characterization, interpretation, application. Characterization is as per 5-star, the threefold test. What is the issue? What's the choice of law rules that tell us which law applies? And which are the laws that apply? Now that's the stage, it's at the characterization stage, and the characterization stage alone, in which the distinction between procedure and substance has relevance. But in fact, it has limited relevance in a case concerning foreign limitation because of the effect of Section 1 of the 84 Act, which tells us that foreign limitation law will be treated as a substantive provision, irrespective of whether or not it is procedural or substantive. It will be treated as if it's substantive. Now, applying the characterization phase, the 5-star test, here there is no dispute but the relevant Iraqi limitation law is Article 435. That's the law that is going to be applied. Now, that takes us then to the interpretation phase. What does that relevant provision mean? What does Article 435 mean? And here, of course, we've had a trial. As would always be the case when it comes to the meaning of foreign law, it's a question of fact to be determined upon expert evidence. We've had that trial of fact, and the findings of the court, which are not challenged before this court, are that 435 in part means, was it impossible to bring the claims in Iraq? That is the foreign law, the applicable foreign law.
Yep.
Is it possible to bring the claims within Iraq? That brings us to the application phase. And all the court has to do there is apply that question. Was it possible to bring proceedings in Iraq? Now, the fact that the answer to that might stem from a law that in phase one, in characterization, may be deemed as procedural for those purposes, depends what the issue is, whether or not it is, but the fact that you look at such a law in phase three in application is utterly, the status of that law is utterly irrelevant. It is merely part of the datum or the factual matrix on which you apply. And that's, my Lord, why I took you to the examples this morning, the equivalent examples in revenue law and penal law. And I took you to Article 17 of Rome. It's no more than the datum. And there is agreement in this case that an Iraqi court answering that question, was it impossible to bring proceedings in Iraq, could only reach one answer. And we see that in the Statements of Facts and Issues, MS 44. We can see, if you start at 43, you can see the following has at all material times of this appeal being common ground.
Yeah.
And then Roman numeral 6, common ground, that it was impossible within the meaning of Article 435 to bring a claim against this defendant in Iraq during the relevant period. Now, the factual matrix, the datum that is relevant, is CPA 17. That it is, under a characterization stage, a law that might be described as procedural is utterly, as I have said, is utterly irrelevant. Now, the only way out for my learned friends is to say that somehow under the 1984 Act there is room for modification of foreign law. Yeah. That even though you have identified the foreign law as meaning one thing, the English court has to modify it so it means another. Now, my Lord, we say with respect, there is no room within the statutory scheme for any theory of transposition. Section 1 says the law relating to limitation shall apply.
But there's no question of modifying foreign law. It's entirely accepted, I suspect, by the respondents that in Iraq there could be no proceedings. What is not accepted is that when you apply Iraq law to English proceedings, there's no room for English proceedings.
No, but under the second phase, when you interpret the relevant law relating to limitation,
Yes.
if the answer to that, as it is here, no longer challenged, that law was it impossible to bring in Iraq,
Yes.
that's the law, that's your starting point. That's what you have to apply.
Yeah.
That is the law in Iraqi proceedings.
Well, no.
It's not the law in English proceedings.
It's what Article 435 means.
Yeah, well,
That was the issue at trial. What does Article 435 mean?
yeah,
And
well,
there was a dispute.
that issue is now no longer an issue, as you
It's
say.
no longer an issue.
That's a given. Yeah.
That's a given. And there was a dispute as to whether or not...
Yes, I know, but it doesn't matter. Though.
Not at all, my lord. And so you've identified that law, and now you must apply it, unless you can see something within the statutory scheme or in the common law
Yeah.
that allows you to modify that test. And our submissions are you can get nothing from FILPA to allow you to modify law. FILPA points entirely the opposite direction. FILPA tells you you have to apply the law as the Iraqi court would do it. Section 1.1 is the law relating to limitation shall apply.
Yes.
It doesn't shall apply, but the court can modify to state the obvious. The fact that it says, for the purposes of the actions that are proceeding before the English courts, takes one nowhere. It's just stating the obvious. It's put beyond doubt, we say, by Section 2.3. Section 2.3, if there was a concern about the impact of law, Section 2.3 could have produced some sort of modification clause, but it doesn't. It's an exclusion clause. And it's not an exclusion clause headed for the avoidance of doubt. It's not an exclusion clause that then leaves an open gate for courts to start adding additional riders. No doubt there are very many occasions when it's said before this court that what you're being asked to do would be to legislate, but this is a prime example. And you'd be legislating, we also say with great respect, through a vehicle of a concept of transposition or modification that is simply unknown, not only in English private international law, but to the best of our researchers in any comparative jurisdiction. There is no concept of modification of foreign law. And indeed, as my Lord Mance noted in the Five-Star case, the push in our own private international laws is the international spirit, and the international position, in common with our domestic position and the European position, is there's no concept of modification. You identify the law that governs the dispute, you apply it unless there is express provision that allows you to do otherwise.
Some modification, if necessary, or at least some transposition involving applying something simply by reference to its new context, is necessary on both sides' submissions, isn't it? I mean, you have to say, but when 435 refers to impossibility, it means hypothetical impossibility in relation to a non-existent action, and that itself involves placing the thing in an artificial context and making appropriate alterations.
But what it is not doing, my Lord, is making appropriate alterations to the applicable law. It's merely postulating a hypothetical example, which is entirely run-of-the-mill, we say, in conflict cases. Can I just take you to a passage from Lord Justice Tomlinson in this case? You turn to MS 142 and to paragraph 23.
Sorry, which page?
It's MS 142, my Lord,
Oh, thank you. Sorry, yes.
paragraph 23.
Yes, thank you.
The task of the English court when applying foreign law is to ascertain how the courts of that foreign country would apply the law of that country to the questions under investigation. That may sometimes involve an element of hypothesis or fiction. The question is whether the Iraqi court would, in the circumstances, regard the ordinary 3-year time period as being suspended. The fact that an Iraqi court would have no occasion to ask a question does not detract from the need to ascertain what its answer would be. On the basis of the judge's findings, the answer would be that the ordinary 3-year time period had been suspended by CPA 13, rendering it impossible for proceedings to be brought. Now, so what's being... there's no sense here of modifying the applicable law. And you get more of that, of the hypothesis, if we look again at Professor Fenterman, which is volume 4, tab 47. Sorry, beg your pardon, supplemental tab 47.
Thank you.
Now, we've already looked at 2020 on supplemental page 229, but see also 2026 for the role of prediction. The court's role is to predict what a foreign judge would do in a like case. As Mr. Justice Kirby in the High Court of Australia said in the Nielsen case, the duty of the judge was not and could never properly be to step in the shoes of a foreign judge exercising the judge's powers as if sitting in the foreign court. Instead, a judge's duty was to ascertain, according to the evidence or other available sources, how the foreign court itself would resolve the substantive rights of the parties in a hypothetical trial conducted before it. As this suggests, there's a proper distinction between impersonating a foreign judge and imagining what a foreign court would do, between deciding the point and determining how it be decided. The distinction is, however, technical. To imagine what a foreign judge would do, an English court must inevitably be familiar with the methodology, assumptions, and perspective of a foreign judge. It involves, in that sense, sharing the foreign judge's thought process. So,
it's a hypothetical trial conducted before it on the same relevant facts, i.e. in this case, that the action is in England.
I'm so sorry.
The hypothetical trial referred to at 226 is a hypothetical trial on the facts which would be relevant to proceedings in England.
My Lord, I'm not sure that one draws that from Professor Fenterman, and we've already gone beyond that stage, because the key stage before is the identification of the test. And the test is, was it impossible to bring it in Iraq? And that is the law you have to apply unless you fall within an express exclusion within FILPA. The only alternative is to legislate your way around it. So, in answer to I'm so sorry.
The question, I think, another way of putting my Lord's question is that the real question is it impossible to bring it in England?
But that's...
If you can envisage an Iraqi judge ever deciding that, he would surely have said, no, it's perfectly possible.
No, because...
But then the difficulty with this sort of statement is that, with the greatest of respect for Professor Fenterman, and that's genuinely meant, he's not dealing with this case. He's dealing with the generality of foreign law issues which normally arise where this sort of procedural problem it simply doesn't arise because one's dealing with substantive rights. What does the contract
My Lord, this is not a procedural problem. We've gone through a three-stage test. We have identified the applicable law, we have interpreted it, and there's no dispute that is what 435 means. Now, it happens in the context of 435 to mean bringing proceedings in Iraq, and that is what you have to apply, absent express statutory sanction to do otherwise. Otherwise, you are introducing into private international law a concept that has hitherto not existed, which is of modifying the applicable foreign law. Now, one might not like the fact that that's what Article 435 says, on the basis of the Iraqi law evidence. One can see how it might give rise to certain problems, but that is what Article 435 means. And FILPA gives you no choice, unless you are within those exceptions, to apply it. And my Lord, that is the simplistic heart of the appellant's case, and it is doing no more, we say with respect, than applying straightforward principles of private international law. And the case against me involves a new development into private international law, that even though you identify what the foreign law means, an English court can apply a law that isn't the foreign law. And it can do so, it can apply a law that isn't the foreign law to reach a result that the foreign court wouldn't. And that is driving in the direct opposite direction to the travel of private international law. My Lords, my Lady, can I finally deal with Ukraneft, if I may, just to put a little more flesh
Yes.
on the bones?
Yes.
Now, the start of the context is extremely important. In order to bring a claim in Russia for civil liability based on criminal conduct, it is necessary, as a rule of Russian practice, for there to be a criminal conviction. No criminal conviction, and a court won't hear you. And so the first relevant question that was posed by the court, applying correct principles of English private international law, was whether this requirement of a criminal conviction was a procedural or substantive bar. It was a liability question. And the court held, see paragraphs 296 to 300, MS 1244, that it was a procedural rule of Russian law. So you could bring a claim in the English courts under a Russian civil wrong provision, even though there was no finding of criminality.
Did it? I thought it sat on the fence, paragraph 302.
No, my lord, you'll see the findings. If you go to 300,
No,
you'll see the acceptance.
look at 302. Under both approaches, that embraces Professor Sergev, the 3-year limitation period would never in practice run from actual awareness.
Yes.
If the matter is one of substance, the law precludes a civil recovery based on a crime without a criminal finding. If the matter is one of practice, the court will not entertain a claim based on a crime, etc.
Well,
and so he's leaving it open, isn't he?
Well, my lord, certainly I would read that in light of 300 as a kind of a belt and braces. At 300, he's wholly satisfied that the claimant's expert on foreign law view is a tenable one. It seems to me likely to be right. If so, the absence of criminal finding doesn't mean that the crime-founded claims cannot, in the English court, be regarded as civilly actionable. In any event, it doesn't matter for the purposes of...
And look at 311. If the sole matter at issue was whether or not the Russian courts would or could dismiss a claim based on criminal conduct on the ground of limitation, I would not have thought it appropriate, despite my doubts about Professor Sergeyev's logic. Is that not the same point? Perhaps not.
No, my lord, it's not on the same. No. It's not on the same point. That's a point about Professor Sergeyev's analysis on the foreign limitation provision as it relates. It's not on the substantive provision.
Yes, no, I see.
And of course, remember, as we can see from 311, this is a summary judgment strikeout application as well, which might also explain some of the language that's used by the court, as if we didn't need any additional complexity in reading this case. But the key feature is that the court was proceeding to assess limitation on the basis of a civil wrong in a case that could not proceed on that basis in a Russian court because of the absence of a criminal finding. And that is the question in which that is the context in which the question about limitation periods arose. Now, in Russian law, there was a general limitation provision that applied for civil claims, and we can see that at paragraph 267, MS 1236. You can see at Article 196 you have a general 3-year period, and under Article 200 there's an extension or a suspension provision, which is the proceeding shall start from the day the person has learned or should have learned about the violation of his right. And on the facts of this case, the claimants knew about it very early on. Now, in Russia, where a civil claim was proceeding on the basis of a criminal conviction, which is the only basis on which it could proceed, Russian courts had developed, again, a rule of practice, but for these purposes, part of the foreign law, a rule of practice that limitation would not run until a criminal conviction. So the time under Article 200 would only run when there had been a criminal conviction. But what the High Court here held is that that was a special rule that applied to cases premised upon a criminal conviction, and where a case was brought without a criminal conviction, then properly construed, the general Russian limitation rule would apply. And that is what paragraphs 311 to 317 address.
Yes.
It's not asking what the limitation period is for a claim in which there has been a criminal conviction and for which there is a special rule. It's asking what's the limitation period for the notional claim before a Russian court of a civil claim brought without a criminal conviction, where the whole rationale for that rule no longer exists. And that is why the High Court reached precisely the same decision as the Russian court would have reached if it was faced with the theoretical position of a civil claim for a criminal wrong absent a criminal conviction. And that is why this case doesn't assist my learned friends at all.
Yes.
My lords, my lady, unless I can assist you any further, those are the submissions on behalf of the appellant.
Thank you very much indeed. Well, grateful to you both for disposing of this matter effectively and well in time. Grateful also to those involved in preparing the written cases. We will consider this matter and let you know our decision in due course. Thank you very much indeed. The court is now adjourned.